Hello and welcome to Legally Norette or Legally Raven Haired. And we are going to talk today about venue. Loving that. So let's see how much we can get done. Sorry, I've been a little distracted because I'm looking for a new couch and I'm all consumed with that. So let's just see how much we can get read between now and 3:27. So venue, we're going to talk about an introduction of venue, the general federal venue statute, the meaning of resident under subsection 1, the meaning of substantial part under subsection 2. We're going to do the oufner v la réunion en français, and that is going to be a case study video. The fallback provisions, specialized venue statutes, and basic venue summary of basic principles. So this is going to take us a while. It's probably going to be a 3 or 4-part video series and reading chapter 11 of Casebook Connect. So an introduction to venue. Previous chapters explain that a trial court must have subject matter jurisdiction over the type of case that a plaintiff has filed, as well as personal jurisdiction over the defendant. This chapter describes another requirement. A court must also have proper venue. What are the basics of venue? Venue refers to a particular court within a court system where a plaintiff can file a suit. For example, in the federal court system, each federal district is a district venue that covers a specific geographic area, such as the Western District of Missouri, the Northern District of Iowa, or the District of Utah. Figure 11.1 shows each of the 94 district venues in the federal court system, as well as the territory covered by the United States Court of Appeals. For example, the United States Court of Appeals in the Ninth Circuit covers a number of Western states, and each of those states has at least one federal district court. The more populous states, such as California, have more than one federal district, more than one possible venue. State court systems are also divided by territory, often by counties or municipalities. For example, in Ohio, the general trial court is called the Court of Common Pleas, and each county has its own court. Overall, there are 84 common pleas courts in Ohio. Given plaintiffs 88. Okay. Overall, there are 88 common pleas courts in Ohio, giving plaintiffs 88 possible venues for filing the most type of cases. And I have heard of the Court of Common Pleas because I'm from Ohio. So here we see all the federal venues, right? And on this map, we see 11. The purpose of venue. Venue requirement exists to ensure that a case is litigated in a court that is conveniently located and has some connection to the lawsuit or both parties. Okay. Venue overlaps the personal jurisdiction in both concepts. Venue overlaps personal jurisdiction in both concepts, often considered the defendant's relationship to the form, but venue is neither constitutionally compelled nor focused exclusively on the defendant's interest. For example, consider a car accident that occurred in Manhattan, New York, which is located within the Southern District of New York, between Powers, a citizen of Connecticut, and Doris, a New Jersey citizen. Assume that Powers has suffered serious injuries and sues Doris in federal court in Buffalo, which is in the Western District of New York, for damages in excess of $75,000. The federal court would have subject matter jurisdiction over this case because it is between citizens of different states and the amount of controversy exceeds $75,000. Moreover, there would be personal jurisdiction over Doris in New York and thus in any federal or state court located in New York because this case arose out of Doris and state context. Thus, the federal court of the Western District of New York would have subject matter jurisdiction over the dispute, diversity jurisdiction. Thus, the federal court of the Western District would have subject matter jurisdiction over the dispute. Over the dispute, and personal jurisdiction over the defendant, specific and personal. The problem is that Buffalo is 400 miles away from the place of the accident and from where either party lives. To prevent cases like Powers from proceeding in a court that has nothing to do with the case, but that happens to be subject matter and personal jurisdiction, Congress has passed venue statutes. These statutes define which federal districts are proper venues to try, in a general way, to restrict litigation to courts that are convenient given the facts of the case and the location of the party. One is from New York, the other is from New Jersey. Manhattan, New York, New Jersey, suffered serious injuries, sues Doris in federal court in Buffalo, which is the Western District of New York, $70,000 federal subject reserve of a case because between citizens of different states and $5,000. Moreover, they would be in personal jurisdiction over Doris in New York, and thus in any federal or state court located in New York, because this case arose out of Doris and state's action. Thus, the federal court of the Western District of New York would have subject matter jurisdiction of the district, diversity, and personal jurisdiction specific and personal. The problem is that Buffalo is 400 miles away from the place of the accident and from where either party lives. To prevent cases like powers from proceeding in a court that has nothing to do with the case, but that happens to have subject matter and personal jurisdiction, Congress has passed venue statutes. These statutes define which federal district courts are proper venues to try, in a general way, to restrict litigation to courts that are convenient given the facts of the case and the location of the parties. Distinguishing venue, subject matter jurisdiction, and personal jurisdiction. Venue differs from subject matter jurisdiction and personal jurisdiction in several important respects. First, unlike subject matter and personal jurisdiction, the Constitution does not restrict a plaintiff's choice of venues. First, unlike the Constitution choice of venues, the Constitution limits a federal subject matter jurisdiction under Article 3 and a court's authority to exercise personal jurisdiction under the Due Process Clause, but the Constitution has nothing to say about venue. Constitution limits a federal court subject matter jurisdiction under Article 3 and of course authority to exercise personal jurisdiction under the Due Process Clause, but the Constitution doesn't say about venue. Second, restrictions. Restrictions on a plaintiff's choice of venue are designed to ensure that the location of the suit is reasonable and convenient given the location of the evidence, the witnesses, and the defendant. In contrast, subject matter jurisdiction is designed to limit a court's power to hear a particular type of dispute. A personal jurisdiction doctrine is designed to ensure that litigation in a particular state is fair to the defendant. Although fairness to the defendant is a concern for both venue and personal jurisdiction, fairness to the defendant is personal jurisdiction's primary concern. In contrast, venue statutes often require examination of the plaintiffs, the witnesses, and the court's connections in the case. Finally, personal jurisdiction focuses on whether a state as a whole is a fair location in which to force the defendant to litigate, whereas venue turns on whether a particular court within a state is a convenient location for the suit. For example, in Power's case, the Western District of New York was a fair location as a matter of personal jurisdiction because the case arose out of Doris' context in the state of New York. But the Western District of New York is not a proper venue because of all the events that relate to the suit occur in the Southern District of New York. 3 requirements for filing a lawsuit: courts that have personal jurisdiction, courts that have subject matter jurisdiction, courts that are the proper venue, courts on which all 3 requirements are satisfied. In sum, a court must not only have subject matter jurisdiction, personal jurisdiction, the court must also be a proper venue. Thus, a court can only hear cases falling within the small shaded area in Figure 11.2 where all 3 circles overlap. So the court has subject matter jurisdiction, the court has personal jurisdiction, and it's the proper venue. State venue statutes. This chapter focuses primarily on the statutes that govern venue in the federal courts. The states have their own venue statutes as well. My goodness. These state statutes tend to recognize a larger number of proper venues than the general federal venue statute. For example, as explained below, the general federal venue statute does not authorize venue in a federal district simply because the plaintiff resides there, though many state statutes authorize venue on that basis. See Shreve, Raven, Hansen, and Guy, section 6.012. Just be aware that in state court, you have to review the applicable state venue statutes, which are similar but not identical to the general venue statutes. The state statutes direct a large number of proper venues in the general federal statute. No. The general federal does not authorize simply because the plaintiff is active. The general federal venue statute. For most federal cases, 28 U.S.C. 1390, section 1391B defines which federal district courts are proper venue. The statute provides as follows. B. Venue in general. A civil action may be brought in, number 1, a judicial district in which the defendant resides if all defendants are residents of the state in which the district is located. Number 2, a judicial district in which a substantial part of the event or omissions can rise to the claim occurred, or a substantial part of the property that is subject to the action is situated, or 3, if there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect. If there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. If there is no district in which an action may otherwise be brought as provided in this section, so that means that there is no judicial district in which the defendant resides if all the defendants are resident of the state where the district is located, and there is not a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, then any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. If there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. These provisions have several noteworthy features. First, if there is any district where the action could be brought under either subsection 1 or 2, subsection 3 does not apply. Because of the breadth of subsections 1 and 2, subsection 3 applies in relatively few cases, typically only when claims arise abroad. Accordingly, most of this chapter focuses on subsections 1 and 2. Second, for any particular case, several venues may be proper. Just as more than one court may have subject matter or personal jurisdiction, more than one court may be a proper venue. Finally, keep in mind how the statute furthers the entrance of convenience and efficiency. Subsection 1 assumes that defendants will not be greatly inconvenienced by having to defend a case in a federal court that is located in a state where all the defendants reside. For example, in Power's case, Doris is from New Jersey. Under Section 1391, the federal court in New Jersey would be an appropriate venue because it would be relatively easy for Doris to defend the case there. Moreover, this court would have an interest in resolving a dispute involving a New Jersey resident. Subsection 2 requires that if a district is located where a substantial part of the events or omissions giving rise to the claim occurred, the district is likely to be an efficient, convenient forum for the lawsuit. For example, Power's case arose out of an accident that occurred in Manhattan, so the Southern District of New York, which encompasses Manhattan, is the proper venue under subsection 2. This makes sense because the evidence and the witnesses are likely to be located in the district. In sum, subsection 1 tells us that the District of New Jersey is a proper venue, and subsection 2 tells us that the Southern District of New York is a proper venue. Thus, Powers can file the lawsuit in either district, at least as a matter of venue. On the other hand, the Western District of New York is not a proper venue. The district does not satisfy subsection 1 or subsection 2 because there are two proper venues. Subsection 3 does not apply. Notes and questions. The general federal venue statute focuses on districts, not states. Recall that venue, unlike personal jurisdiction, focuses on connections to specific federal districts, not to entire states. With that reminder, try the following questions. So venue, connections to specific federal district, not states. Reconsider Powers' Manhattan car accident, which involved Powers, a citizen of Connecticut, and Doris, a New Jersey citizen. Recall that Powers has suffered serious injury and sued Doris in federal court in Buffalo, which is in the Western District of New York, for damages in excess of $75,000. But now change one fact. Assume that Doris, the only defendant, is not a resident of New Jersey, but rather a resident of Albany, New York, which is located in the Northern District of New York. Powers, the Connecticut plaintiff, wants to file her claim in federal court. In which districts would venue be proper? Okay. Any federal district in New York, the Northern District of New York only, the Southern District of New York only, the Northern District and Southern District of New York only, the Northern District of New York and the District of Connecticut only, the Northern District of New York and the Southern District of New York and the District of Connecticut only. So I think it is D, because it happened in the Southern District and the defendant lives in the Northern District. According to subsection 1, venue is property in judicial district with the defendant resides if all the defendants are resident of the state in which the district is located. Hence, there is only one defendant, so all defendants are resident of the state in which the district is located. Critically, the focus here is on the judicial district where Doris resides and not on the state that she resides. In this case, Doris resides in Albany, which is in the Northern District, so although Doris is subject to personal jurisdiction anywhere in New York, venue is proper under subsection 1 only in the Northern District of New York. The plaintiff's Connecticut home is irrelevant for venue purposes. Subsection 1 focuses only on the defendant's state of residence, so E and F are wrong. B is not the answer because we must also consider subsection 2. The accident occurred in Manhattan, which is in the Southern District of New York. So the Southern District of New York is the judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. Because the Northern District of New York is a proper venue under subsection 1, and the Southern District is a proper venue under subsection 2, the answer is D. Woo-hoo. Multiple defendants. Try this variation, which includes an additional defendant. Now imagine that the Manhattan car accident involves Powers, a resident of Connecticut, Doris, a resident of Albany, New York, and Donald, a resident of Buffalo, New York, which is in the Western District of New York. Powers wants to sue both Doris and Donald in federal court, alleging that they both caused the accident. Which venue is proper in this case? The Southern District of New York only, because the Northern District of New York and the Southern District of New York and the Western District of New York only. So the Federal District of New York, including, what is this? How does it go? The judicial district in which any defendant arises if all defendants are residents say, oh no, it's in all three because one is in the Western, one is in the Northern. So it can be either one of those if they're both in New York, which they are, and then the Southern where it happened. So A. Star reception while all defendants are resident in New York, so venue is proper in any district in New York in which a defendant resides. In this case, that means that both the Western District of New York where Donna resides and the Northern District of New York where Doris resides are proper venues for subsection 1. Of course, the Southern District is also proper venue under subsection 2 for the reasons explained earlier. Thus, the answer is A. Multiple defendants redux. This variation adds some complexity. Read subsection 1 closely. Now imagine the same facts in the previous example, except Donald is a resident of Vermont. Where is the venue proper in this case? In the Southern District of New York only B, because all the residents have to be residents of the state for you to be able to do it in any district in which they live. Start with subsection 1 as all defendants are residents of the same state. In this case, they are not. Doris resides in New York and Donald resides in Vermont, so there's no proper venue under subsection 1. Now under subsection 2, the Southern District of New York is still proper under the subsection, and there does not appear to be any other district where a substantial part of the events or omission giving rise to the claim occurred. Accordingly, the Southern District of New York is the only proper venue. The answer is B. Districts and divisions. Some federal districts are divided into different divisions that are located in different cities. For example, the Northern District of Illinois has courts located in an Eastern Division, Chicago, and a Western Division, Rockford. The Chicago and Rockford courts are both in the same district, the Northern District of Illinois, but are located in different cities. The federal venue statutes are concerned with districts, not divisions. But be aware that these additional choices within districts sometimes exist and are often governed by local rules. So sometimes a district is larger, I'm assuming. Why else would you divide it? And so you divide it. So we have the Northern District of Illinois, and that is the district. However, it is divided into the Eastern Division, notice, and then that's Chicago, and the Western Division, which is Rockford. So the federal venue statutes are concerned with districts, not divisions, but be aware that additional choices within districts sometimes exist, and they're often governed by local rules. So which do you need to do it in the Eastern Division or the Western Division? That's going to probably or likely be governed by local rules. The meaning of resident under subsection 1. Subsection 1 uses the word resident, which can give different meanings depending on whether a litigant is an individual, a corporation, or a non-corporate entity. That's so true. What is a resident? I think it's simple, but it's not. The definition of resident for individuals. The preceding hypotheticals assume that each party's resident was clear. But what if a party's resident is ambiguous? For example, if Doris had a home in two different states, where would her residence be under subsection 1? For some time, there was disagreement as to the answer, but in 2011, Congress resolved the matter by amending 28 USC section 1391C1. This statute now provides for all venue purposes, a natural person, including an alien lawfully admitted to a permanent resident in the United States, shall be deemed to reside in the judicial district where the person is domiciled. Thus, for purpose of interpreting subsection 1, a person will be considered to reside in the state where she is domiciled. The case law suggests that most courts will apply the concept of domicile in much the same way they do in the context of diversity jurisdiction. See the discussion on this issue in chapter 3. Okay, the definition of resident for corporation and other entities. Where do corporate and non-corporate entities reside for venue purposes? Section 1391C2 and D offer guidance. Residency for venue purposes. An entity with the capacity to sue and to be sued in its common name under applicable law, whether or not incorporated, shall be deemed to reside if a defendant in any judicial district in which such defendant is subject to the court's personal jurisdiction with respect to the civil action in question, and if a plaintiff only in the judicial district, and if a plaintiff only in the judicial district in which it maintains its principal place of business. It resides in any judicial district. So, in any judicial district in which such defendant is subject to personal jurisdiction with respect to civil action in question. If a plaintiff only in the judicial district in which it maintains. Okay, civil action in question. And if a plaintiff only uses the judicial district in which it maintains a principal place of business. So the plaintiff has to be where they maintain their principal place of business, and for a defendant, any place where there is subject to the court's personal jurisdiction for a civil action. Residency of corporations and state with multiple districts. For example, for purposes of venues under the chapter, in a state which has more than one judicial district and in which a defendant, that is, a corporation, is subject to personal jurisdiction at the time an action is commenced, such corporation shall be deemed to reside in any district in that state, within which its contacts would be sufficient to subject it to personal jurisdiction if that district were a separate state. And if there is no such district, the corporation shall be deemed to reside in the district within which it has the most significant contact. And in which a defendant, that is a corporation, is subject to personal jurisdiction at the time of the action is, such a corporation shall be deemed to reside in any district in the state within which its contacts would be sufficient to subject it to personal jurisdiction if that district were a separate state. And if there is no such district, the corporation shall be deemed to reside in the district within which it has the most significant contact. Where they would be subject to personal jurisdiction if that district were a separate state. And if there's no such district, the corporation shall be deemed to reside in the district within which it has the most significant contact. In general, therefore, entities reside in every federal district where they would be subject to personal jurisdiction. If that district were its own state. To make sense of this definition, we offer a few examples before. Notice and questions, venue in cases against corporations and other entities. Determining where entities reside. Peggy, a South Carolina resident, sues Devo Corp in federal court. Peggy alleges that Devo manufactured a project that injured Peggy at her home in Southern California. Devo manufactured the product in Sacramento, California. In the 11th in the Eastern District of California, and mailed it from Sacramento to Peggy's home in South Carolina after Peggy uh, placed an order from there via the internet. In addition to accepting internet orders that are processed in Sacramento, Ohio, Devo has 4 stores in Los Angeles, which is in the Central District of California. Assume that Devo has its place of incorporation in Delaware and its principal place of business in San Diego, which is in the Southern District of California. Also assume that Devo has no contacts in any district not mentioned here. Identify every district where venue would be proper. Where would it be proper? I'm thinking both in the Eastern District and in the Southern District. Start with subsection 1. There is a single defendant DEFCO, so venue will be proper in every district where Devo resides. Section 1391C and 1391D2, when read together, provide that a corporate defendant resides for venue purposes in any district where it will be subject to personal jurisdiction if that district was viewed as its own state. In this case, Devo will be subject to general jurisdiction in the districts where it is incorporated and has its principal place of business, the District of Delaware and the Southern District of California, respectively. Devo would be subject to specific jurisdiction in 2 districts. First, Devo sent the allegedly defective product to South Carolina, so specific jurisdiction will be proper there. There also will be specific jurisdiction in the Eastern District of California because the case arose out of manufacturing of the product there. Because Devo is subject to personal jurisdiction in each of these districts, Devo is considered to reside in each of these districts for purposes of subsection 1. In sum, venue is properly proper in the Southern District of California, the District of Delaware, the District of South Carolina, and the Eastern District of California. In contrast, the Central District of California is probably not a proper venue, even though Devo has significant presence there. None of the stores located there gave rise to the particular claim. And after Daimler, it seems reasonably clear that these stories are not sufficient to subject Devo to general jurisdiction. But wait a minute, isn't Devo subject to general jurisdiction everywhere in California, given that its principal place of business is in San Diego, the Southern District of California? Devo is indeed subject to general jurisdiction in California, but remember that venue requires that we look at each district as if it were a separate state. Devo has no contacts in the Northern District of California, so if the Northern District were considered a separate state, Devo would not be subject to personal jurisdiction there. Similarly, although Devo has contacts in the Central District of California where it has stores, Devo would not be subject to personal jurisdiction in the Central District if the Central District were considered a separate state. Accordingly, venue is not proper in either the Northern District or Central Districts of California. The distinction between venue and personal jurisdiction makes sense given that 2 concepts serve different purposes. Personal jurisdiction protects the defendant, whereas venue protects the defendant, whereas venue focuses on the overall convenience and efficiency of litigating in a particular district. Put another way, it may be fair as a matter of personal jurisdiction to require Devo to defend the lawsuit anywhere in California, but only certain federal districts offer reasonably convenient location for this lawsuit given the location of the parties, the witnesses, and the evidence. Finally, under subsection 2, venue will be proper in the District of South Carolina because that is where the product malfunctioned and Peggy was injured. The Eastern District of California is also likely a proper venue under this subsection because the product was manufactured there. Of course, these 2 districts are already proper venues under subsection 1, so the subsection does not authorize any additional. So this subsection does not authorize any additional venues on these facts. Subsection 1 and multiple corporate defendants. Imagine that Company 1 has its place of incorporation and principal place of business in Idaho, and that Company 2 has its place of incorporation in Idaho, but its principal place of business in North Dakota. Each state has only one federal district. If a plaintiff sues both companies in the same lawsuit in federal court, would there be proper venue under subsection 1? No, because there are different states. Corporate defendants only need one shared district of residence under 1391C to satisfy subsection 1. And in this case, there is one, the District of Idaho. Yeah, because company two has its place of incorporation in Idaho, but its principal place of business in North Dakota. And in this case, there is one District of Idaho. Company one resides there, as does company two. Corporate versus non-corporate entity distinction. Until recently, 28 USC 1391C applied only to corporations, so courts had no clear authority for determining the residence of non-corporate entities, such as in partnerships. In 2011, Congress resolved the ambiguity by amending 1391C so that the statute now explicitly applies both to corporations and non-corporate entities. Although this amendment offers much needed clarity, it is inconsistent with the way courts treat non-corporate entities. When analyzing diversity jurisdiction, in that context, non-corporate entities are treated as citizens of every state in which one of their members is domiciled. There does not appear to be a sound conceptual reason for treating non-corporate entities differently in these two situations. The dichotomy appears to be a product of historical circumstances. The law in these two areas developed separately over a long period of time rather than as the result of some conceptually coherent approach to the status of legal entities. In this context, non-corporate entities are treated as citizens of every state in which one of the members is domiciled. There does not appear to be a sound conceptual reason for treating non-corporate entities differently in these two situations. The dichotomy appears to be a product of historical circumstances. The law of these two develops over a long time. All right, so that's the end of Legally Raven here for today. Goodbye.